Welcome everyone to this webinar. We're so glad to have you here today. I will begin here as we start filling the room, but I will give it another 30 seconds for everyone to join us for today's webinar. All right, I see more and more folks are joining. I'm looking forward to the discussion that we're having today. So I'll go ahead and kick us off now for this webinar. You found us. Welcome, everyone, and thank you so much for joining us on today's webinar, Defending Indigenous Peoples' Rights, Challenging Harmful Business Practices Through the OECD Complaint Mechanism. We're so glad to present to you this technical information that connects directly to the health and wellness and well-being of Indigenous peoples. This webinar has been co-organized by Voices, by OECD Watch, by the SIRGE Coalition, and by Tallgrass Institute. By way of introduction, my name is Kate Finn. I am a member of the Osage Nation. I am the director of the Tallgrass Institute and chair of the executive committee of the SIRGE Coalition. And our work at the SIRGE Coalition is to uplift the urgent need for free, prior, and informed consent to audiences around the world in order to elevate the self-determined priorities of Indigenous peoples. So we're pleased to be here today to present this information and this critical and key information that's been put together by Voices. Just by way of housekeeping, let me go through a couple things here. First of all, please note that there is interpretation. You'll see at the bottom of your screen a globe, and there is interpretation channels today in English, Portuguese, and Spanish at the bottom of your screen. This session is being recorded, so please note that. And please do feel free at any time to ask questions in the Q&A tab at the bottom of the screen. We will also be asking the speakers questions during the presentation. So some of your questions will answer during the conversation and some of the questions we'll bring here into the discussion. So please do feel free to ask your questions. We look forward to answering them and to bringing a very robust discussion to you today. I will just remind everyone that we do have interpreters, so a reminder to speak slowly and clearly so we can make sure that this information gets out and about. So what we want to do today, our goals here with this webinar is to introduce the OECD Guidelines and Complaint System as one tool that Indigenous peoples can use in defense of their land and their rights. So this webinar will provide insights into how this mechanism works in practice, outline potential advantages, but also clearly delineate the limitations of filing a complaint and to explore how a complaint can be embedded within a broader land and rights and defense strategy. So this webinar aims to support Indigenous people specifically in making strategic decisions about whether and how they wish to use this as an accountability mechanism as a part of their broader efforts, and will facilitate the exchange of experiences to highlight specific case studies from Guatemala, Peru, and Nepal. This webinar is also a continuation of multiple efforts to share the handbook that was created by Voices, which is an OECD handbook for filing complaints against, to look at filing complaints against harmful business practices. So we will share this later on in the session. Before we move on to the lived experiences and to talking specifically about case studies with practice, I would like to present a keynote presentation from OECD Watch to hear an introduction about the OECD guidelines and the complaint mechanism. So I have the pleasure of introducing to you Catherine Booth, who is a consultant for the OECD Watch, a global civil society network that is formally recognized as a representative of the OECD Committee and promotes the OECD Guidelines. OECD Watch undertakes a range of activities centered on empowering communities, rights defenders, and civil society to use these mechanisms. So without further ado, Catherine, please come in.
Thanks very much. Could my slides please be shared? Great. For me, they're quite small, but perhaps someone can just check in the chat that they're big enough for others to see. They're okay for other people? Okay. I see that one person they're okay for. I'll just have a moment. Sorry, can someone just confirm that I can...
At the moment, we see two screens, one with the SIRGE Coalition and one with your desktop.
Yeah, it's I think it's Juan's or Denny's desktop.
All right, now we see the slide. Can we go to the next slide? So we still see two screens, but this is the slide. I believe that's the presentation.
Sure. I will get started in any case. So hi everyone, my name's Catherine. I'm going to be briefly talking about three topics today. The first is the OECD, the second is the OECD Guidelines, and the third are national contact point, not NCP complaints. So turning to what's on the screen, the first question is, what is the OECD? So the OECD stands for the Organization for Economic Cooperation and Development. And this is an intergovernmental organization of 38 governments. And at this organization, governments talk about economic, social, and development challenges, and they try to resolve those challenges. Now, for our purposes today, the OECD is a global standard setter, and one of its focus areas is responsible business conduct or corporate accountability. Next slide, please. So the next question is, what are the OECD guidelines? So this is a document that you can see on the right side of the screen. They are recommendations or standards that were made by those OECD governments, and they're directed to companies. So they're recommendations as to what companies should be doing to act responsibly and to be good citizens. Next slide, please. So very, very briefly, I'm going to outline some key strengths and limitations of the OECD guidelines. The first strength is that they're backed by those OECD governments, but also by other governments that are members of the OECD. So in total, there are 52 governments that have backed these standards and that promote these standards to companies. So that's very significant. And then they're very, very broad. So they cover every sector. So they cover financial sector, mining sector, garment sector, for example. Every sector is covered. They cover many, many issues. Just to name a few: human rights, Indigenous Peoples' rights, land rights, environmental issues, just transition. Disclosure is also covered. AI is also covered, for example. And they're very broad in terms of the countries that are covered. So as long as there is an OECD link, then that company can be covered by the OECD guidelines. And they also look upstream and downstream in a value chain. So they have a whole value chain approach. So that is also a key strength of the OECD guidelines. But the biggest limitation is that they are recommendations, they are standards, they are voluntary standards, and they're non-binding for companies. So that means that companies are encouraged to follow them, but this isn't the law. There is no legal requirement to follow these standards by companies. Next slide, please. So turning to national contact points, or NCPs for short, what are they? These are government bodies that are established in the guidelines. So every government that has committed to following the guidelines has an NCP, and one of their purposes is to handle complaints against companies. So it's important to note that these complaints are non-judicial complaints, meaning NCPs are not courts. They are focused on mediation. So dialogue between the complainant, the Indigenous group that files a complaint, and the company against which a complaint is made. So very important to keep in mind that they're not courts. They're really focused on talking between the parties. Next slide, please. So broadly speaking, there's three types of outcomes in a complaint. The first is an agreement. So that's really the purpose of dialogue. That's the main point of dialogue. Agreement on company actions to either remedy harm or to prevent harm. So remedy to fix a harm. Examples is very, very broad. Environmental rehabilitation, for example, reporting and investigations, return of land that has been taken, but very broad. And agreements can also cover prevention of harm. So improvements to company policies and practices like their human rights policy, their environmental policy, or their due diligence policies, and also agreements to strengthen community engagement in the future and to ensure, for example, epic or meaningful stakeholder engagement in the future. But even if no agreement is reached, there are possibilities for a case. So one of those is that NCP can make recommendations for the company to better align with the guidelines in the future. These are very common. Another outcome is some NCPs, but not all, can make determinations or decisions as to whether a company followed the guidelines in a specific case. And another possibility, and this is also quite rare though, is some NCPs can ask for consequences from other government ministries to penalize or withhold benefits if the company either didn't act in good faith during the mediation or they did not follow the guidelines. There's also a third outcome that happens through an NCP complaint, and then complaints can lead to impractical action by others. So you can focus on media attention, you can garner attention to an issue, governments can act as a result of an NCP complaint. And you can also put pressure on investors, and that can lead to different outcomes, including more pressure on the company against which you file a complaint. So they're broadly speaking, the three types of outcomes. Next slide. So since 2001, OECD Watch has been tracking complaints filed by communities and non-profit or non-government organizations. And there have been 465 cases filed so far in those years. So as an example, of all of those 465 cases, around 11% have resulted in an agreement. Around 10% have related to Indigenous peoples or have been filed by Indigenous peoples. And those complaints have dealt with lots of different sectors. So energy sectors, financial sector, infrastructure and mining sectors. Those complaints, Indigenous peoples complaints, have focused on these different sectors. And Indigenous peoples complaints have also raised issues in 34 countries. So again, very, very broad spectrum of complaints. Next slide, please. That's very briefly my presentation on the OECD Guidelines and NCPs. Please keep in touch. Thanks, Kate.
Thank you so much, Catherine. We appreciate it and appreciate your expertise. We'll be in the Q&A chat here as we continue on with our discussion for any technical questions that do come up. It's my pleasure now to introduce Sylvia Schoenberger, who is the Program Manager on Climate Justice and Indigenous Peoples' Rights at Voices. Voices, which is formerly the Society for Threatened Peoples Switzerland, is a human rights organization based in Switzerland and a founding member of the SIRGE Coalition. Voices has filed 3 complaints with the Swiss National Contact Point of the OECD against Swiss investors in the past, So Sylvia has firsthand knowledge and will talk about the pros and cons of complaints and specific considerations for Indigenous peoples when filing a complaint. So let me welcome Sylvia here to the stage.
Hello, everyone. Thank you for the introduction, Kate. You can share my presentation. Yeah. So, over the next few minutes, I would like to share some key considerations for anyone thinking about filing a complaint with a national contact point under the OECD guidelines. And I will highlight a number of factors that can help inform whether this mechanism is the right option for your case. So before deciding to file a complaint under the OECD guidelines, it's important to take a step back and carefully assess the opportunities, challenges, and strategic implications of engaging with the NCP process. And some of the key questions to consider include who can submit a complaint? So the NCP complaint system is relatively accessible, so any person or organization with an interest in the issue may submit a complaint. This includes directly affected Indigenous peoples, communities, associations, or federations, as well as NGOs, workers' organizations, trade unions, and supporting allies. Then, against whom can complaints be filed? Complaints can be filed against multinational enterprises connected to a harm. This may include the company directly operating a project, but also parent companies, subsidiaries, suppliers, buyers, investors, joint ventures, or other business partners. The key point is that the company must be linked to a country that adheres to the OECD guidelines. Then, where can complaints be filed? Usually, complaints can be submitted either in the country where the harm occurred, if that country has a national contact point, or in the country where the company is headquartered. So, in some situations, complaints even may be filed in more than one country to more than one national contact point. And what kinds of issues can be raised? As Catherine already mentioned, the OECD guidelines address a broad range of impacts, including environmental destruction, labor rights violations, human rights abuses, impacts on cultural heritage, or failures to respect free, prior, and informed consent, to just mention some. At the same time, communities affected by harmful business practices should carefully consider the potential risks of filing a complaint. So an NCP may reject the complaint or conclude that the company did not breach the guidelines, which could be used to challenge or discredit the community's advocacy efforts. In some contexts, communities may also face intimidation, retaliation, increased pressure, or attempts to divide communities by companies, state actors, or security personnel. So, for these reasons, it is important to assess security risks, develop appropriate safety measures, and identify support needs, and consider how an NCP complaint fits within a broader advocacy strategy before proceeding. Next slide, please. So before deciding whether an NCP complaint is the right tool, it's important to weigh both its strengths and its limitations. One of the main advantages of a NCP process is that it is generally more accessible than court litigation. It is often faster and less costly, and there is no requirement to hire legal representation or an advocate. So most complaints take between 1 and 3 years to complete, followed by an additional follow-up period to up to 1 year. The process is designed to promote dialogue and negotiated solutions rather than adversarial legal proceedings. Even when a complaint process does not result in a mutual agreement between the complainant and the company, positive outcomes are still possible, as Catherine mentioned. Nancy P. may issue findings or recommendations helping to increase public awareness, visibility, and pressure on the company. Complaints can also support communities' broader advocacy objectives and create opportunities to advance policy or systemic changes beyond the individual case. At the same time, it's important to have the limitations in mind. Participation by the companies in the process is voluntary, and NCP's outcomes are not legally binding. NCP also do not have enforcement powers, which means that the impact of a complaint can be uncertain. In addition, NCP structures, roles, and overall performances vary greatly from country to country. So while some NCPs have substantial experience and capacity to handle complaints, others may face institutional or resource constraints that can affect how the process is conducted. Next slide, please. So an NCP complaint should not be viewed as a standalone solution, but rather as one tool within a broader strategy to defend rights and seek accountability. In many cases, NCP complaints are most effective when combined with other forms of advocacy and community-led actions. This may include direct engagement with companies, investors, business partners, as well as the use of the company's own grievance mechanisms. Communities may also pursue litigation before national, regional, or international courts or file complaints with government agencies, national human rights institutions, or other accountability mechanisms. In some cases, engagement with UN human rights mechanisms, including treaty bodies or special rapporteurs, may also be appropriate. And at the same time, public campaigns, media outreach, and alliances with other affected communities and civil society organizations can help build visibility, strengthen support, and increase pressure for change. The next slide, please. For Indigenous communities or organizations interested in exploring this complaint mechanism further, Voices and the SIRGE Coalition, together with partner organizations and experts, recently developed a detailed handbook which provides step-by-step guidance and on the complaint process, practical considerations for preparing and for filing a complaint, and specific guidance tailored to Indigenous peoples' rights and contexts. So if you have any questions or would like further information, please do not hesitate to reach out to us. Thank you so much for your attention.
Thank you so much, Sylvia. And let me underscore this handbook as a practical tool for folks as you are considering whether or not filing a complaint makes sense in your broader strategic view. This is a tool that we hope as SIRGE is really, really useful to understand the pros and cons and to understand where you can fit this in your broader strategy. And I see here on the call among the participants several organizations that work in this area, and so grateful to have everyone here to stand alongside Indigenous peoples considering this particular strategy. So moving forward, I'd like to move on to this next section where we will look to understand what the use of this mechanism looks like in practice. So now we will move to 3 different cases from around the world to understand what this looks like on the ground and what this looks like as part of a broader strategy. So again, it's my pleasure to introduce to you Apu Robinson Sandi Hualingwe. Robinson served as the leader of his community Caceres for 15 years until his election in 2024 as president of the Quechua Indigenous Organization of the Peru-Ecuador border. As president, he's part of the Puinamut platform, which brings together 5 federations representing Indigenous peoples affected by more than 50 years of oil pollution. So without further ado, I would like to introduce Robinson to bring us more information on those cases. Robinson?
Sí, buenos días a todos y a todas.
Yes,
A
a good
través de
day
este
to
medio es un
everybody
placer de poder
through
saludarlos
this medium. I'm very
y al
happy
mismo
to
tiempo
be
tal
able
vez
to greet you and at
poderlo
the same
expresar
time
allí
express to
en este
you,
momento,
in this
esperando
case,
desarrollar
hoping
mis
to
saludos
develop,
cordiales del norte de la Amazonía
sending,
peruana.
first of all,
Por
my
estar presente
cordial
y
greetings
podemos
from
desarrollar
the
este
northern
proceso y
area of the
compartir también
Amazons. I'm
la
very happy to
experiencia que
be
se puede
here
llevar
to
y se viene
basically
teniendo
present
en
the
sitios
experience
contaminados,
that we've been
tal cual como
having
nosotros
in the
subsistimos
case
acá
of
en nuestros
our
territorios
contaminated areas.
por
We continue
años
to
y
insist
décadas que han
in our
sido
territories
explorados
or within our
hidrocarburos en nuestro
territories that
territorio.
have been explored and where there's been fossil fuel extraction.
Thank you so much for bringing the experience. I have a question for you. Despite the company's refusal to participate in the mediation process in good faith, the NCP did issue findings and recommendations. What did that final report mean to you and to your community?
Bueno, cuando nosotros sabemos
Well,
de que acerca de este resultado del punto nacional de contacto,
regarding
bueno,
this
para nosotros vamos a decir
national
un
point of
avance
contact
porque
result,
sabemos
for
y
us, it
identificamos
is
quién es el
advancing because
responsable.
we know
Entonces,
and
porque
we
en un momento
identify
cuando
who's
se quiso
responsible,
presentar lo que es
right?
la
Because at
denuncia,
some moment when
ya,
this
pero
complaint was presented
se ha optado
and
por
submitted,
una queja, ya, entonces,
this
cuando nos dio el
complaint,
resultado, decimos,
when the
bueno, ahora sí
result
tenemos un
came
mecanismo, tenemos
back,
un
we
instrumento
said,
para poder
well,
seguir
we
y
have a
ver cuáles son los
mechanism now,
pasos
we
a
have
seguir
a
adelante,
tool in order to know
porque
what would
no
be
era,
the
si bien es
upcoming
cierto, cuando
steps,
alguien
right?
tiene que presentar una
It's
denuncia,
like
tiene que
when you
tener
have
las
to present a
pruebas
complaint, you have to have the
contundentes
evidence,
para poder
right?
denunciar a alguien.
Very
Entonces, creo que
strong
esa
and
labor
solid
muy
evidence.
importante lo
So
hizo
again, this is
el
a
Punto
very
Nacional de
important
Contacto. Estamos agradecidos por esa
aspect that was
parte
done
y
by the national
esperando
point of
seguir
contact.
el
And we're
proceso
very
que viene.
thankful and we're hoping for what's up and what's next in the process. Thank you.
Thank you so much. Um, I have a more technical question, but what led you to file a complaint with the Dutch National Contact Point? And what was the decision behind bringing the case against a Netherlands-based company, and what made that significant?
Ya, a nosotros lo que nos llevó
I
a
see. Well,
presentar esta
what led
queja
us to
a
present this
una empresa que se
complaint
encuentra
to a company
con
that
sede en
is
Países Bajos, en
with,
Holanda,
their headquarters
fue en un
in the
momento cuando
Netherlands
nosotros nos
was
unimos,
because
en este caso tres cuencas, que es Corriente,
it was at
Río
a
Corriente,
point
Río
where we're
Tigre,
in
Río
this
Pastaza,
watershed,
donde
right? We
viven los
have three
pueblos
rivers,
quichuas,
Rio
quechuas
Corriente,
y
Rio
achuar.
Tigre, and Rio
Nos hemos
Pasta.
dado
This is where
cuenta
the Quichuas, the
que
Quechuas,
la
and the
necesidad
Achar
era el
peoples
mismo,
live.
la
And
necesidad
we
era el mismo,
realized
donde
that the
crecía
need was
impactado
the same,
por
right?
hidrocarburos,
We
la
were all
contaminación, todo
impacted
esto y la
by
remediación en
fossil
nuestros
fuel
territorios que
contamination,
quedaron
and we were
a causa de
awaiting
la
remediation in
exploración
our
del
territory
hidrocarburo.
as a product of the exploration of fossil fuels.
Wonderful. Thank you. I have one more question for you. I understand that filing with the NCP is one aspect of your strategy. What is the goal for all of these Indigenous peoples that are part of your federation? What is it you look forward to have happening? What do you look forward to doing on your land once you are in the next phase?
La noticia más ansiada que nosotros esperamos
The
de
news
poder
that we're
conseguir un
mostly
día, sé
awaiting
que no es
for is
fácil,
that
tampoco es
we may be able to
difícil,
get it. We
pero
know that
estamos en
it's
este
not easy,
proceso
but
de
it
que
shouldn't be
quisiéramos
hard either.
que nuestros
What
territorios
we
sean
are
remediados,
expecting
que el
is that
pueblo
our
y
territory
las
is
comunidades, los
remediated,
hermanos que
that
vivimos
the
en aquel
peoples, the
lugar, seamos
community, the
atendidos en los
sisters and
sistemas de
brothers that
salud,
live in that
en temas de salud,
area, we're
educación, porque
remediated in terms
imagínense,
of health, in terms of
con el grado de
education. Because can you
contaminación que ha
imagine with the
impactado
level
nuestros
of
territorios,
pollution that
se
has
ha propagado
impacted our
diferentes tipos
territories,
de enfermedades.
we
esta
have endured
contaminación de
a
hidrocarburos no
series of
solamente
illnesses through
ha
the
causado
contamination
impacto
of fossil
territorial,
fuels that
sino
has not
también en
only
lo
impacted our
cultural,
territory,
en
but
lo
also
social.
our culture
Entonces,
in the
todo
social
esto fue un
aspects.
impacto
And
muy,
so
muy
all of
complicado
this
para
was a
nosotros. Entonces,
very
para
hard
ello,
impact.
tal vez lo que
And so
necesitamos es, por
for
parte
us,
territorial, que
what we
sean
need on a
remediados estos
territorial
territorios.
level to be remediated
Y
with
tal
our
vez
territories,
recapacitaciones,
and
reformulamientos de
also
taller, capacitación para poder
to
nosotros
perhaps reformulate through
dignificar, o
training,
sea, rehabilitar
maybe
nuestras costumbres,
find the way
nuestros
to
idiomas
once
en eso,
again
porque eso se está
recover our
perdiéndose
language,
acá en
our
nuestros territorios.
livelihoods, because this has been lost right now in our territories.
So much. And thank you so much for the reminder of what is true. Let me take a moment of moderator privilege here to underscore a point that you just made. And I get to see at my desk every day, which is looking out at the global Indigenous world. And that is that it is more than just land that we are protecting. The land is there, but the land, it also brings forth from it the language, the culture, our cultural understanding, our relationships with our people and our humans, our relationships with our non human relatives. And so, protection of the land is protection of culture, it is protection of people. And health and wellness in the land is the same and spread among all of those ecosystems and networks. So, thank you so much for that reminder that we are here today to talk about a very specific advocacy mechanism and a very specific kind of complaint, but it is in service to protection of the land and wellness, of culture and language of our children and of our future generations as well. So thank you so much. And with that, I will move forward in our session today to introduce our next speaker and our next case. Pravindra Shakya is a human rights activist from Nepal's Indigenous Newar community. Pravin is currently the director of the Community Empowerment and Social Justice Network that he founded. He is also the convener of Asia Indigenous Peoples Network on Extractive Industries and Energy. And he is an expert in this space in so many different ways. So, with that, I'll welcome you, Pravin, to speak about the cases that you have filed.
Zosalapa, Namaste, Kate, and everyone. Firstly, let me thank Voices, SARS Coalition, Tallgrass Institute, and OECD Watch for organizing this important webinar and for inviting me to share a case or share some experiences from our from our um, from our advocacy using the OECD Multinational Enterprises Guidelines for defending indigenous peoples' rights against harmful business practices in Nepal and beyond. Please give me a thumbs up if you can see my screen before I move any further. It should come up now. Yeah. Okay. Yeah.
Yes.
Yes, thanks, Kate. Yeah, so the case that I'm sharing about today is about indigenous Newar, particularly indigenous Newar Pradhan communities that are in Tamil, which is the tourist district of Kathmandu, that have been fighting to revive, to restore their sacred pond and surrounding lands that have been encroached upon over a century or beyond a century, beyond a century, it started during the dictatorial Rana regime in Nepal, which was an oligarchy when a Rana dictator eyed the sacred pond and wanted, he wanted to include or incorporate the pond within the palace that he built in the area, but and it was contested or protested against by the local indigenous Newar communities back then itself. As a result, there was an agreement that the access there will still be provided. The communities will still be provided access to the pond and the surrounding lands because this pond held cultural value. The water from the pond was used for daily worship to this deity that you can see on the left, on the to this deity in the local monastery, that for which there is also an annual fair, as well as the surrounding lands of the pond was used for death rites and other cultural rituals. But over the years, the successors of the Rana dictator gradually eroded the access and eventually even transformed the land ownership from a guti, which is our traditional land ownership, traditional land tenure system, whereby land is held as a collective, as an endowment for cultural or religious purposes, from a guti to a tenant to a tenant land ownership title. Later, they even turned it into an individual land, or using their tenancy. While the Nepal's laws do not even allow any tenancy on guti lands, particularly on pond. The pond was eventually filled up, and fast forward to later or late 1990s or early 2000s, and a huge mega business complex was erected on the pond that is projected as a Thamel within the Thamel, or a mega mini Thamel, which is a 15-story business complex called Chaya Center, owned by some of the powerful business people and business houses, as with strong political connections. This land encroachment has faced continued resistance by the indigenous Newar leaders, Newar locals, as well as cultural activists, from streets to courts. There have been number of court cases against the transfer of land titles, um, against the issuance of the building approval permits, against the so-called agreement that was held between the Guti representatives and the land, the land tenants, the so-called land tenants, and the company that eventually became was handed over to the company that built the Science Center Business Complex. At the same time, there have been numerous protests on the street by the cultural activists and human rights activists, including indigenous leaders, over the years, over the decades, and which have continued till date. The court processes have been slow, and despite the court processes, because of the use of their political influence as well as corrupt practices in the government, the company, Chaya Devi Complex Private Limited, was eventually able to build the complex Science Center, and was even able to operationalize the Science Center since 2014 or 2015. Once the business complex was operationalized, we came to learn that the largest source of revenue for the business complex was to be a local franchise of Marriott International, a third party franchise as they call it, called Aloft Hotels, as well as which basically rented Aloft Hotels basically rented 10 of the 15 floors for a 5-star or luxury hotel project. At the same time, a significant portion of the fifth and fourth floor was also leased out to VFS Global, Visa Facilitation Services Global, which is the visa handling services provider based in Switzerland, while Marriott International is based in the US. Accordingly, while the national law and litigation processes and street ground mobilizations were ongoing, as well as other administrative legal options were being undertaken, the local campaign that was leading to restore the archaeological or sacred pond called Kamal Pokhari, as in Nepali, or Paleswa Puku in Nepal Bhasa, decided to file a complaint against Marriott International with the U.S. National Contact Point using the OECD Multinational Enterprises Guidelines in 2023. But this OECD this OECD complaint that was filed in 2023 is yet to bear any result. After a year, of filing the complaint against the Merit International at the U.S. National Contact Point, which is the OECD's complaint mechanism, as has been already explained, because of lack of progress, anonymous organizations also filed complaint against VFS Global, the Visa Facilitation Services Global, at the Swiss National Contact Point, because there was the need to diversify targets or advocacy targets. What has been despite delays in the processes, as well as despite many challenges within the processes, there have been some positive outcomes in the processes. For example, VFS Global has decided to relocate from the business complex, from Chai Center business complex. Although VFS Global did not categorically say that the decision to relocate was due to the human rights concerns over the land dispute. It came about, or the decision was informed as part of the investigation process by the Swiss NCP into the complaint against VFS Global. At the same time, while there has been limited or no progress in the NCP complaint against the Merit International, basically because they have been escaping from the responsibility by giving various excuses, such as they did their due diligence or legal due diligence, as they first call it, or the ongoing risk assessment. They basically denied that they were aware about the land dispute, and they were aware about any human rights concerns. But despite that, because of continued advocacy of the indigenous defenders, as well as the support groups with the UN mechanisms, such as the UN Special Rapporteur on the Rights of Indigenous Peoples, the UN Working Group on Business and Human Rights, there have been increasing pressure on Merit International in particular, as well as the governments of Nepal and the US, specifically to address the retaliations against human rights defenders, or by Chai Center or Chai Center Business Complex representatives, whereby the lead defender of the campaign, Mr. Bhagwat Narsingh Pradhan, has been facing judicial harassment. He has faced threats by the so-called trade union leaders of the workers engaged at the business complex, and by visiting his house, and among other different reprisals. There have been lots of challenges throughout this process. One of the key challenges is that there was lack of documentation, or lack of documentation in English, to be particular. So what we have learned is documentation is very important. We tried to address this, or the campaign tried to address this, by developing timeline of the violations, as well as the advocacies at local and international levels. The biggest challenge that the complainants faced, or the defenders faced, in their engagement with the NCPs, was that the NCPs have very limited mandate, so we really had to manage our expectations. The mediation function of the NCPs is very technical, so it is voluntary, and as in both complaints against the NCPs with the Swiss or and the US NCPs, neither Merit International nor VFS Global voluntarily came for accepted the mediation offer, so there was no mediation at all. Of course, there was the language, technology, and other barriers. And the other key challenge that we faced was, in our understanding, in indigenous Newar understanding of remedy, the remedies should start from acknowledgement of harm. But the NCP's processes did not lead to any acknowledgement of harm by any of these multinational enterprises involved. What we have learned more recently is, for effective functioning of the NCPs, the political context of home states also matter. So more recently, the US NCP has not been responsive at all, particularly after the incoming of the Trump regime in 2025. Earlier, there was at least some progress, but with some draft statements being shared, but for the last couple of years, there hasn't been any progress at all. And as I said earlier, while there was risks against defenders, in particularly the lead defender. There were also, we could also feel that those security risks could be exacerbated. So the use of anonymity is very important. In this particular case, the Science Center, the company that was building the Science Center, even threatened the OHCHR, the UN Human Rights Office, of legal actions because of the press release that they put up against the Merit International, or directed to the Merit International, to stop retaliations against the defenders. No, so that also is evident of how serious the security risks can be. And finally, one of the biggest, the other key challenge, or practical key challenge, that we faced with regards to NCP processes was that defenders on the ground require extensive accompaniment to walk through the whole process. But given the outcomes, given the challenges, I think we learned a lot of important lessons throughout the way. That, the first lessons being that we need to use complementary strategies, and in those complementary strategies, ground resistance is key. So there has been, again, continued protests against this science center complex, particularly during the court hearings. During the times of the court hearings, to draw media attention. Media attention is also important, of course. And what we have learned is network and alliance building, such as with OECD Watts, that can provide technical advice, and even advisory support, has also been very significant. Has also been key for our engagement, leveraging the OECD guidelines. UN advocacy and investors advocacy has also been important, and particularly shareholder advocacy against Marriott International has been useful for us, whereby Tallgrass Institute has been very helpful to help engage with investor shareholders of Marriott International through Investors and Indigenous Peoples Working Group. While we were not able to have any direct engagement with company or funders, I think if that opportunity allows, that would also be a very important strategy. Building on these challenges, on strategies and lessons, we have been trying to build more experiences of leveraging the OECD guidelines for defenders beyond Nepal, such as in India and Indonesia. In my engagement with the Asia Indigenous Peoples Network on Extractive Industries and Energy, APNI, and more recently, APNI has supported filing a complaint against Hyatt Hotels. APNI has supported filing complaint against Hyatt Hotels with the US NCP again for its involvement with the proposed 5-star hotel project near Kaziranga National Park in Assam, that is threatening evictions of 45 Adivasi families and other environmental impacts. But as I said earlier, with the US NCP, there hasn't been much progress at all. Although this complaint was filed in March, there hasn't been any action from the US NCP beyond an acknowledgement of receipt. So, of course, the engagement with NCPs really depends on which NCP you are engaging with, and what other complementary strategies that you are using. And I think that those are the key lessons that I would like to share here. I thank you for your attention. I hope this was useful. Thank you, Kate, and thank you, the organizers, again.
Thank you so much, Pravin, for bringing your experience into this space. Having worked with you, I know that you take all of this with a great deal of expertise and care in all of these different engagements. I just want to underscore one thing that you said that's so common, and that is that often when companies go into a country, they take all of their information about Indigenous peoples from the country itself, but they fail to do that extra level of due diligence to understand who are the people on the ground now, who were the people prior, who were the people prior to colonization, and what are those ties? And that is exactly what has exacerbated the issues at the Chaya Center, and I know has been part of these engagements is that the companies can say, well, there was already something there, but in fact, that land was sacred far prior. So I want to just highlight that to say that by the time companies come in, oftentimes there is already acknowledgement on the ground. There is already that this place is in need of enhanced protection. There can be social protests. There can be defenders already there, and it can already be quite a dangerous situation for defenders, even as you're starting a complaint to the NCP. So I know we don't have much time, but I wanted to ask, And you covered this a little bit, but given that relatively few complaints have been filed anonymously, how did the NCP receive and handle that request to maintain anonymity? And I guess just in a minute or so, how would you advise other Indigenous peoples who are seeking that kind of anonymity in this process?
Yeah, for us again, since the lead defender for in Nepal was already facing reprisals, and it has been the same experience in our case in India too. No, in the NCP complaint in India too, anonymity, at least at the beginning of at the time of filing the complaint, it has been key. To make sure that there is no immediate or exacerbated risk at as soon as the complaint has been filed. Of course, what we learned in our engagement with the US or Swiss NCPs for the complaint that we filed from Nepal, is that they said during the dispute resolution or the mediation, during the mediation, they will not be able to ensure confidentiality or anonymity of the complainants. But we first, where we held steadfast was, if we were to enter into a mediation, we first needed certain measures put in place. First we wanted the company and the companies involved to already have an acknowledgement that that they have been wrongdoing, and only then we would be able to get into further mediation. But again, neither of the companies were even willing to get into the table with us, get on the other side of the table with us, let alone acknowledge the wrongdoing. So the anonymity of the complainants was never compromised. For me, I would definitely say that at least at the time of filing the complaint, anonymity would be it would be the best issue, and it would be the best safeguard or best prevention. And even for the negotiation stage, because a lot of these negotiations, at least in our case, were planned to be held online. I think the anonymity could be continued and could be put in place, or could be maintained in place to ensure that security risks are not exacerbated. One last point that I would make on the make to that, Kate, is that anonymity is of course never foolproof, right? I mean, the companies can always tell who has been filing the complaint, because they know who have been protesting on the ground, and who are these indigenous leaders who would take this internationally. But at least NCPs, I think, if when we put that clause with the NCPs, we put that condition with the NCPs, I think that puts additional burden, or at least, let's not say additional burden, or additional responsibilities on the NCPs to understand the security risks, which I think helps that defenders are not put on put are not put to face unnecessary risks, I would say, like, or even I would say, I would not say unnecessary risks, but I would say undue risks, I think that is the word, no? And yeah, I think anonymity, has been important for us, and I think that should be used by others too.
Thank you so much. And thank you for highlighting the need for safeguards to protect the folks that are part of these complaints. And even as it goes into mediation, this is an important consideration for folks who want to use this process. So thank you so much, Pravin, for your presentation. And we look forward to asking you more questions. I see that there are lots of questions in the chat and in the Q&A, and I would invite everyone to continue to please put in all of your questions. We will have a Q&A session with the speakers after this next presentation. So we are on the backstage here collecting all of those questions so that we can be sure to bring them to the presenters. So without further ado, let me introduce to you our third case for today. This case is from Guatemala. I'd like to introduce you to Ana Rutilia Icalchuk, who is a Maya Quechua lawyer, linguist, and indigenous rights defender from Guatemala, who has played a leading role in legal efforts to protect Indigenous territories and the Cabon River from the impacts of large-scale hydroelectric projects. So thank you so much for joining us. The floor is yours, Anna.
Soy Soledad Pérez. Un saludo cordial para todas y todos. Soy
Greetings,
Maya Techi.
a cordial
Soy
greeting
Ana
to all of
Rutilia
you.
Ilcalchoc.
My name is Ana Rutilia Ilcalchoc.
Brevemente
I
la
want to
experiencia
tell you a little bit
que
about the
nosotros hemos
experience
tenido
that we've
desde
had
Guatemala
from
en
Guatemala
utilizar este mecanismo
while
este
using
espacio
this
de los
complaint
puntos nacionales
mechanism,
de contacto
or at least this
para
space of
interponer
national
una denuncia, una
contact
queja.
point to
Y que
present
en
a
ese
complaint
momento
and
pues,
file
fue muy
it.
oportuno
So at the
porque
moment we did this
nosotros
was
pues
very
acá
opportune
también en el año
because us
2017
here in
mi persona
2017,
interpuso una acción
myself, I
constitucional de amparo
presented a
ante
constitutional
la Corte
protection
Suprema de
action
Justicia.
before
Y
the
también
Supreme
ese
Court.
mismo año
And
en compañía con la
in the
ONG
same year,
Alianza por la
along with the
Solidaridad
NGO
que está en
Solidarity
Madrid, España,
Alliance that
interpusimos esta
has an
queja
office in Madrid,
ante el
in
Punto
Spain,
Nacional de
we
Contacto.
presented this complaint through the national
Esto
point of
fue
contact.
en el mes de
And
noviembre
this was
de
in the month of
2017
November
y entonces
2017.
el
And
Punto Nacional de Contacto
the national
pues
contact point
empezó a ver ese caso, ¿verdad?
started
Y
looking
eso
at
está
this case
relacionado
since then,
de
and this
una
is
empresa
related
española como contratista
to
del
a,
proyecto
a Spanish
hidroeléctrico
company
que está
that
ubicado
invested
en
on the
territorio donde
Renace
estoy ahorita, que se
hydroelectric
llama
project.
San Pedro Carchá, es en el
This
norte del
is
país, aquí en Guatemala.
in San Pedro Carchá, in
Renace
the northern area
es un
of the
complejo
country in Guatemala.
hidroeléctrico
So Renace
compuesto
is a
de
hydroelectric
cinco
complex
subproyectos
comprising
que
5
está dentro del
sub-projects
río Cabo,
that
que
are
es un
within the
río
Cabon River.
que atraviesa el
Again, this is a
territorio
river that
de Alta
crosses
Verapaz
along
y
the Alta
desemboca
Verapaz
en un lago que se
territory,
llama Izabal, que está en
and
el Atlántico de
the
Guatemala.
river ends up
Y
at the
también el río
Pisabal
Caribe,
area,
un
which
río
is
de agua
the Atlantic
turquesa,
side of
protegido
Guatemala.
históricamente por el pueblo
So
quechí. Sin
these
embargo,
are
el estado de
turquoise
Guatemala
waters that
desde
have
el
been
año de
historically protected by the
1992-93,
Quiche
el estado
peoples.
concesionó
And even
esos
though
dos
the
ríos
Guatemala
a esta,
state
a esta empresa hidroeléctrica, ¿verdad?
had
Renace.
had
Es
to
una sociedad
the
anónima
diligence of
y la abrió
protecting
por
this
50
river,
años.
they
Sin,
basically
pues,
gave the
preguntarle
permission
a los
out to
pueblos
this
o
hydroelectric project
pedirles
without consulting
hacerles una
the
consulta,
peoples,
¿verdad?
without
Entonces,
asking them first through a
también
consultation. And so
la hidroeléctrica Renace
the Renace
subcontrató
hydroelectric
a una
dam
empresa,
or project subcontracted
la
another company,
Multiinversiones, la CMI,
the
subcontrató a una
CMI,
empresa
for
española para la construcción de los Renaces 2,
multi-investment
3 y 4.
to build
Entonces
Renaces
ahí vemos
1,
el Renace
3,
1,
and 4.
que
So
es
here we
la
have an image of
primera
Renace 1,
hidroeléctrica
which is the first
y que ustedes
hydroelectric
ven que
plant.
genera
And
muchísima
as you can
energía.
see, it generates a
Y
lot
ya
of
está
energy.
generando, está produciendo energía,
It's
pero
producing
no para el
energy,
consumo
but it's
local ni
not
nacional,
for the
sino para
local use or
exportarla a
national use, but
Centroamérica y
rather to
México. Entonces,
basically export it to Central America
ese
and
es el
Mexico.
Renace 1.
So
El
this is
Renace 2
Renace 1.
también está ahí,
Renace 2
surge en el año 2011.
comes about
Y también, es uno
2011,
de los complejos,
and this is
es una de las hidro más
another
grandes. Y ahí podemos
of the
ver
biggest
la
dams within this
fotografía, cómo
complex. You
la
can see
empresa
here
esa
in the
destruyó
image
totalmente el
how the
entorno
company has
natural
completely
del
devastated the
territorio
natural
costero de San
environment
Pedro Carchá.
of this
Y
territory,
bueno,
San Pedro
ha
Carcha,
dejado
and has
esa
left
destrucción total, ¿verdad?
by
Y
this
produce 114
destruction,
megavatios potencia.
and it
El
produces
Renace 3
114
también en el
megawatts
2012
in
está
energy.
también ahí
So
y con
2012 is Renace
66
3. This produces
MW. Entonces vemos la
66
destrucción del
megawatts.
entorno
Again, we see the
natural
destruction of the natural environment
del pueblo quechí
of
que
the
se ubica
Quechí
en San Pedro
peoples
Carchá.
that are
También
within
el
San
Renace
Pedro
4,
Carcha.
que el
Renace
Renace 4 es
4th
donde se toma
This is where the Caliche River is taken. This is a turquoise colored water of the river. And you can see this is very visible infrastructure by the hydroelectric dam. You can really see here how Renace hydroelectric project, along with the Cobra company of Florentino Perez, they basically moved the regular stream, and this is where the resistance of the people comes about. And we said no more due to the divergence of this natural flow of the river. So these hydroelectric plants were built without free, prior, and informed consent to the indigenous peoples Quechí, which are at the San Pueblo Carchapi territory. Again, the Renace companies and the Cobra company by Florentino or owner Florentino, they violated our right to be consulted. And within the impacts that were used as an argument at this national point of contact that was given to the instances in Spain. So we have basically the environmental impacts and the impacts to the lives of the Quechí peoples. And so there's basically this diminishing of the river flow, the ecological flow, they call it, the Cabon River. And we as human beings, what is happening is that it's breaking and destroying the social weaving and the social thread, because this environmental pollution, before this actually came about, they promoted this pollution by detonating and basically affecting the whole area, what they call it the influenced area around all those places that were detonated and exploded. And again, people continue moving away from the territory. People are actually migrating to the United States. So besides the poverty, there's a scarcity of water. The water has become a commodity, meaning if you want water, you need to have the money to purchase it, otherwise you will die. And so this is the imposition to peoples. Another level of imposition is the religious sects and religious groups. This is another part of the very Machiavellic type of policy that is set there to divide us as peoples. So it is the dispossession of our lands. With Renace 1, 2, 3, and 4, there's a systematic dispossession of land from the people's cooperative processes that we held. And what they left behind, the company has been alcoholism, prostitution, some Quechil women, in order to satisfy the sexual instincts of these foreign engineers that came here to work. We have this as the many impacts. So we have sexual violations, we have rape, we have child pregnancies, teen pregnancies, and low level of education. So again, this is 2017, and there was a wave of solidarity that was built, and as part of the guidelines that are established, according to us, what we consider to be vulnerable, and as part of our alliance with Solidarity Alliance in Spain, we set up a series of aspects as part of the guidelines, right, coming from the OECD for multinational companies, especially those within Chapter 6, regarding the environment, and also Chapter 10 regarding general principles. This is where it's established on point A-2 to respect the human rights, international human rights for the people that are affected due to the activities, and also the due diligence on the implementation when it comes to the management systems, identifying, preventing, and decreasing the impacts, real and potential, described in the sections 10 and 12. So as we can see here, there is a total lack of compliance when it comes to Renace, this multinational company, and also the company that used to be called Cobra, now it's not called that way, of these OECD guidelines. Again, and what is it that we were looking towards when we were basically creating this? We wanted the suspension of Renace 4. The other ones had already begun, but Renace 4 was just about to begin. And so we started building on, I mean, there was no respect of these points in the guidelines, right? In the case of all the previous projects, but also on Renace 4. We were also requesting a consultation as part of the ILO convention, and this is supposed to happen, right? This is supposed to be done for indigenous peoples, as well as comprehensive environmental impact evaluation, specifically when it came to the complex, the whole hydroelectric complex Renace. So as part of the national point of contact, this happened in Madrid, in Spain, and the case was studied. They met many times, and what predominates here is the mediation, the dialogue, mutual respect, and all of this was, assured for both parts, the people that were the complaints, the people that were complaining, and the other part, which are the companies. So there was a series of arguments that were presented that were well fundamented and well established. These were basically conviction elements. I mean, we really wanted this case to not fall through, and it was fruitful. A series of meetings were held, and that same year, also in 2019, I had my participation as well, where I contributed with the lack of consultation, the environmental destruction by this multinational company. At that moment, it was called the Cobra company, owned by Florentino, and we started this protection measure. In 2019, we also received the resolution coming from the national point of contact, listening to both parts, and it was actually real good, right? Because I couldn't really say that it wasn't. I mean, it had its positive and negative aspects, of course, but what was most important was that in 2019, we also received, as Chique people, the possibility to put into action this resource, this protection mechanism. So the Supreme Court grants us this protection measure, basically favors us, this favorable resolution, and we ended up denouncing the violation of our rights due to the building of this complex, one of the biggest hydroelectric complexes in Central America. So it was favorable to us, and they basically called to the Ministry of Energy and Mines in Guatemala to produce this consultation. I mean, it wasn't going to be a prior consultation, but we set up a series of consultation, and this was already by then by the Verapaz hydroelectric project. And again, this was very satisfactory because In 2019, we were granted this protection mechanism, and we also obtained this resolution. What came about as a resolution from the national point of contact, one of the assessments that the PNC came about with was, it focused its work on determining the impact of the complex had on the communities, and of course the possible ways to mitigate it if it was negative. So again, the PNC valued this positively, what came from the rulings by the Supreme Court of Justice, and of course granting the protection mechanism. So, but it also valued the indicators that were presented by RENACE. Nonetheless, within the assessments by PNC regarding the environmental impact, there is both positive and negative assessments. And so this is how we can present them as positive and negative. From the positive ones comes that RENACE has a sort of a natural reserve, but of course, we have many, right? It's not that RENACE is going to hand us a recipe on reserves, right? I mean, we do already have an idea of what a national valued habitat is. They just came and destroyed, but we've already known this. And so we know this very well. So besides that, this negative emphasis was also on the fact that there is how the flow of the river was moved, was displaced. We see this as a negative assessment. So there's a series of recommendations that have been presented, and these were very opportune. One of the recommendations that since this is a multinational Spanish company, part of these complaints was that the guidelines from the OECD, when it comes to multinational companies, they're very strict when it comes to due diligence, and also when it comes to complying with the highest international standards beyond just complying with the legalities of the place that this project is set up at, right? So also the Spanish company, the knowledge that the indigenous communities in this case, of possible damage, and omitting this information was part of the due diligence that the OECD guidelines presented. So I asked the Spanish company to review their policy on human rights, because even though the Convention 169, ILOs, when it comes to providing certain documents, because before you execute any project within indigenous territory, the indigenous people need to be consulted. This is an international mechanism, the 169 Convention. So again, have it quite clear on the rights of indigenous peoples. So that's my experience. I could summarize it generally like this. And using these mechanisms, not a lot of countries have this possibility, but some of them do. But it allows us basically to place these complaints towards this national points of contact in this case, but also it could be about labor rights. It could be environmental pollution and so on. So I do believe that, I mean, for me, I recommend it. I want to continue using it because in my territory, in this country, in Guatemala, it's not just the topic of the hydroelectric projects that we have many. We have another set of extractivist projects that each day diminishes our lives, and we're not consulted, and it's basically against the natural environment. And so So it also goes against the planet. And let's remember that we only have one. So I will leave it there. And thank you, Padosh, in the Quechua language. Thank you. And I am attentive to your questions. Thank you so much.
Thank you so much for your presentation, and thank you so much for all of the work that you've done to bring this forward to us today. I want to highlight a couple of things that you have said that are so common. I'm so glad that one of the outcomes of this is to highlight the need for robust due diligence by companies in the first instance, for companies to really understand more than what the state is telling them about Indigenous peoples on the ground. And I hope that that is a lesson that we take from this webinar, but that we can take widely into the private sector, that there is a need for more due diligence. And that due diligence isn't only about risk to the business, though that is where it can be framed. It is about the well-being and the fabric of the community and the economic options of that community moving forward. As you noted, the fabric of the community is just as important as anything else. What does protection of people, of Indigenous women and children look like on the ground during development? And what does it look like for a local economy, not just for 10 years, not just for 15 years, but for the future and for future generations? So thank you so much for all of this work. There are so many good questions coming in to the chat right now, and we only have time for very few. I wanted to highlight very quickly that if you look at the OECD Watch's webpage, there are guidelines on Indigenous peoples, and those guidelines refer to the UN Declaration on the Rights of Indigenous Peoples and to free, prior, and informed consent. And so we just want to highlight that most recently, the OECD guidelines in 2023 did recognize the impacts of company activities on Indigenous peoples, but there is still a lot of work that will go into filing a complaint, but we know that there are mechanisms that folks can refer to there. So let me just very quickly, we only have time for a couple of questions. But I know that folks in the chat and folks attending today, there are a number of people representing Indigenous peoples who are either not recognized by the state or who have not been understood as Indigenous peoples in their own right. And so I wanted to just throw this question quickly to Sylvia and perhaps to you, Prabhan, as well, for folks whose land is not recognized, for folks whose indigeneity is not recognized. What can they do in terms of filing this complaint, and how can this complaint be of use to them? So Sylvia, can I throw that question to you?
Thank you, Kate. Actually, this is a very, very hard question because, on the basis that if Indigenous peoples are not recognized and their territories are not recognized, this is on the basis problem of the national legislation. And to file a complaint at an NCP, actually there must be an multinational enterprise involved somehow to take to open this pathway to file a complaint against the enterprise, but this will not really change the problematic of not recognizing a territoriality. So there must be other ways and not the OECD complaint mechanism, actually.
Yes, go ahead, Prabhan. You spoke about all of the different strategies, so I'm interested in your perspective.
Firstly, I think recognition, lack of legal recognition or official recognition of Indigenous peoples is one of the key challenges for indigenous peoples across Asia, because as we know, many Asian states do not recognize indigenous peoples as distinct groups with collective and individual rights in line with the UN Declaration on the Rights of Indigenous Peoples and ILO Convention 169 or ILO Convention 169. No, so in our experiences, again, when we have been leveraging OECD multinational enterprises guidelines to file complaints with the national contact points, I think the lack of legal recognition has not been a barrier. Of course, the case that I shared was from Nepal, where indigenous nationalities or indigenous peoples are officially recognized. In India, indigenous peoples are not recognized as such. We are working on complaints, NCP complaints from Indonesia, whereby again indigenous peoples are not recognized as such. But we need to understand that NCPs are guided by OECD multinational enterprises guidelines, whereby enterprises or business enterprises are recommended to follow international human rights laws, not national laws. No, so if we can make a case to the NCPs that these are indigenous peoples because of these characteristics in line with these international laws, or in line with the criteria set by the UN, I think leveraging the OECD multinational enterprises guidelines for indigenous groups that are not officially recognized by the states might not be such a big issue. Secondly, I would also say, again, OECD guidelines, or the NCPs are guided by the OECD multinational enterprises guidelines that require or that recommends businesses to respect internationally recognized human rights. So that might not necessarily only mean the UN Declaration on the Rights of Indigenous Peoples. That might also mean other international treaties, or other international conventions that I think could be referred to or could be leveraged. But at the same time, the OECD guidelines have environmental requirements on environment, have requirements on due diligence or risk in human rights due diligence, and I think those are the provisions, or those are the requirements or recommendations under the OECD multinational enterprises guidelines that can be used, or that can be referred to, even if the indigenous peoples are not recognized as indigenous peoples by the states. But of course, a lot of our fights are for our rights as indigenous peoples, including to free, prior, and informed consent, and to self-determination. So I would still suggest that we make that case, we argue for respect of those rights by enterprises, even when our states are not recognizing indigenous peoples. And again, these complaints are filed to the home states of the multinational enterprises, not to our host states or to our countries. No, so yeah, the laws of our countries are not the primary laws that the NCPs base their investigation or their processes on. If I have 1 minute, Kate, there was a very interesting question, if we would consider, if the presenters would consider OECD mechanism effective. I would say I'm very torn on that. I would definitely not suggest the communities that we are working with, or the defenders that we are working with, to only depend on OECD complaint mechanism, to use it as a complementary strategy with a lot of other strategies, other international advocacy strategies and national advocacy strategies. And as I said, also, to give a big significance to ground resistance, because without ground resistance, I think just depending on an OECD complaint or NCP complaint or a complaint to the UN might not produce the result that we want, or at least the timely result that we want. So yeah, I mean, I'm torn on that, but I would say, there's no silver bullet for advocacy of our rights. So yeah, we need to knock on as many doors as we can. Of course, it takes a lot of resources, but of course there are also support groups that can help us, such as once we build our networks and alliances. I hope that was useful, Kate.
Yes, thank you. Thank you so much, Pravin. I fully agree that, in fact, it takes an entire ecosystem in order to really make sure that land is protected, that people are protected, that culture and language is protected. And so to sort of at parallel answer some of the questions in the chat, I would say that it takes all of us to really ensure the safety of the defenders on the ground, to ensure that these complaints can get to, as Pravin said, they are filed in the state where the multinational business is located. That requires allyship with folks in that state. It requires very technical knowledge of the OECD guidelines. All of this is information and expertise that we collectively can bring together to support Indigenous peoples who want to file these types of complaints. And it takes truly all of us to make sure that we can forward these protections. I know we have just a couple minutes left. I wanted to ask one more question. I know Robinson didn't have much of a chance to speak to the community, and so I just wanted to ask if you have a moment for us, Robinson, to talk about what the situation is on the ground at this moment, and have there been any changes after the filing of this complaint?
Sí, ¿qué tal? Entonces, no
Hello, just
mencionar
to mention that if there was a
espacios, si es que hubo
change
un cambio
from
después de la
the
presentación de la
since the
queja,
complaint to
hasta
up
el
to date, there has
momento
been no
no hubo
changes.
en el tema territorial, no hay
Quite
nada.
the opposite.
Al
The
contrario, los pasivos ambientales que
companies
en su
have
momento han sido
they're still there, but they
dejados,
have
se
nothing.
encuentran aún todavía
Not even
latentes
a
porque no se ha
one
remediado
square centimeter has
ni
been
un
remediated
centímetro
because we
cuadrado,
basically are located
porque nos
in
encontramos
a
básicamente
state in our country of
en
Peru
un estado
where
de nuestro país,
there is
Perú,
little
donde
importance
que poca
given to
importancia
this
le dan,
area, despite the fact that
a
there
pesar
the
de que hay
existence
leyes
of laws that
ambientales que
protect the
protegen la flora,
environment
la
and our
fauna,
flora and
nuestros
fauna.
territorios.
They
Sin embargo,
ignore
a
all
eso
of this to be able
hacen
to
caso
not
omiso
carry out
para
any type
poder
of
realizar
remediation.
las
They put up
remediaciones.
all
Entonces
sorts of
ponen trabas, más trabas que
pretexts
aún
for not
todavía no se ha
doing it,
podido
excuses.
realizar. Y frente a la queja
And now
presentado
the national point of
en
contact, the NCP in
el
Hull
Fondo Nacional de
in the
Contacto
Netherlands,
en
even
Holanda,
with that, we still
ya
don't
de frente a
have
esto,
any, as you
aún
could say, any
todavía
type
no
of
tenemos, vamos a
action
decir,
from the
acciones tal
company
vez que por
that
la
at
parte de
in
la
the time
empresa
plus
que en su
petrol with
momento
they're
la Plus
located in
Petrol,
Argentina,
ya con residencia en Argentina, donde lo cual
and then the Netherlands, where the headquarters
en Países Bajos
are.
y de la central,
This
la sede,
company
donde
has
que
always been acting this
esta
way, where
empresa
they
siempre se ha camuflado, vamos a decir de esa manera, donde
use
que usa
a
como
protection there to hide it from
una
a
protección
place that,
ahí
to say that this
a
is a
esconderse en un lugar
prestigious
haciéndose de que
company.
tal vez es una
Here, from my
empresa
point of view, I would say
prestigiosa. Yo
maybe in
desde
the
acá diría,
to
tal
the
vez
Netherlands, maybe
al
they
Países
create
Bajos,
establish laws in
que
their
tal vez se
territories
crean leyes
that
en sus
cannot
territorios
protect
que
these types
no
of
puedan
companies,
proteger
these
a
types
ese
of
tipo
companies that have done
de
so much
empresas,
damage in
a
other
ese tipo de
countries
empresas que han
is to
causado
their
tanto
environments.
daños en otros países con el tema
And this is
ambiental.
what many times
Entonces,
the biggest concern
esto es
for
lo que a
us,
nosotros
because
muchas veces
look,
nos está preocupando, porque
where we are
sabemos,
at
mira, en el lote donde nosotros estamos ubicados, son
is in the
más
year that they have been
en el
operating
año
the
que
Plus
ha
Petrol, the
operado, en el
company,
año que ha
more than
operado la Plus Petrol,
3,249
más de
impacted sites that they've
3.249
left in our
sitios
territory. That,
impactados que ha
as we've
dejado en el
mentioned, that
territorio,
they have
que
still
aún
not
todavía, como vuelvo a
remediated
mencionar, ni un
even one
centímetro han
centimeter of
sido
that.
han sido
The
remediados.
water
Vertimiento del agua
the
también,
water has been
que ha sido
contaminated, this
salido para
pollution,
el agua, o sea, para los ríos,
and
esa
through that,
contaminación,
they've done a
donde a través de
toxicology
eso
report,
se ha hecho un examen
a
toxicológico
blood
para
test, and
hacer el
that have
examen de
resulted,
estudio de la
it was
sangre y se
shown
encontró
all
de
types of
metales
heavy
pesados,
metals,
mercurio,
arsenic,
bario,
lead,
plomo,
and we
cadmio,
are
arsénico,
polluted
donde nosotros
our
estamos
bodies for
contaminados,
life
vamos a
as a
decir, de
result of
por
this
vida a causa
contamination and pollution.
de
And
esta
they
contaminación.
told us that the
Dentro de eso, a
company,
nosotros nos dijeron, diciendo
the
que la
exploration of
empresa,
hydrocarbons
la
brings
exploración de hidrocarburos
progress and
trae
lifts up the
progreso, trae
territories, and that is
surgimiento en los
completely a lie.
territorios.
They have
Y es
now
falso.
condemned
Y es
us for
falso, porque al
life.
contrario nos ha
It's
dejado
also
condenados de
polluted our
por vida.
water, our right
También
to
contaminando
food,
nuestro agua,
our right
contaminando
to
al
our
derecho de la
territory, our right to our
alimentación,
free
derecho
determination,
de otro territorio, del
because
derecho a la
this is
libre
very complex,
determinación,
it's very
porque
complicated,
es
that
muy
we
complejo,
have
es muy
to
complicado
face this.
esto
There has
que
not been
nosotros tenemos
any
que
changes
afrontar
because
ahora.
there is
No
no
hubo ningún
will
cambio
from the
porque no hay
company
ningún
still, and
pronunciamiento por
us
parte de la empresa aún
here
todavía
waiting
y
and
nosotros
dreaming that
esperando tal
maybe in the
vez
future
soñamos que en
we might
adelante tal vez
receive some type of
poder
a
tener
response from this company,
una
and
atención
because
por
the
esta empresa,
remediation of
por
this
esta empresa, porque
territory
para
is
la
a very,
remediación
very
la
high
remediación de
amount
ese
that we
territorio es una
consider
suma
more
muy
than
alta, muy alta que nosotros
1,500 million
consideramos más de
soles,
1.500
approximately,
millones de
for the
soles
state, according
aproximadamente
to the study
por
that
la
Probonampe
entidad,
carried out.
según el
And
estudio que realizó
also,
Probonampe. Según
it's also something that's very
entonces
complicated
eso
to us. We still don't
es
have
para
any
nosotros muy
answer that we're
complicado. No
expecting
tenemos esa
to
respuesta aún
remediate our
todavía que
territories.
necesitamos esperar para remediar nuestros territorios.
Thank you so much. And thank you for the reminder that once companies have entered, oftentimes the damage is irreparable. And so, what we need to do, in addition to filing these complaints, is to remind businesses continually and prior to their engagement of their responsibility to respect the human rights of Indigenous peoples under the UN Guiding Principles on Business and Human Rights. And my many thanks to Ms. Lorenzo for reminding us of those guidelines and the need for all of us to get in front of this development and to remind companies of those responsibilities over and over and over again so that we can protect communities. With that, I know we are 1 minute over, and I want to thank all of the presenters for coming and for sharing your experiences, sharing your work and expertise. Thank you so much. Thank you so much to Catherine and to Sylvia for your continued work on these national contact points and for making sure that there are places and that there are information and tools for Indigenous peoples who wish to use these advocacy strategies. So thank you all to the participants for joining us today, for joining this conversation, for making it a live discussion in the chat. Please see the links here to the OECD handbook. It is available on the SIRGE website in Spanish, English, and Portuguese. We will also be sharing this webinar in the SIRGE Coalition YouTube channel. So please follow along with all of SIRGE's social media and on our website to gather up more information. So with that, many thanks to everyone for joining us today. And I hope to see you in discussions in the future. Thank you so much.